Number 8 is Clarke versus the town of Newburgh.
Me,
Good morning.
Misha Tsalin for the town of Newburgh. Apropos of your comments earlier, as a lifelong Atlanta Braves fan, I certainly appreciate the Mets letting their foot off the gas in Game 2 so we could all enjoy the playoffs.
You're a
today.
Braves fan.
That's right, Your
Wonderful.
Honor.
Well, good for you. Well, everybody in that game was happy yesterday, right? Everybody's going to be playing today.
We all enjoyed ourselves on the field afterwards, drinking champagne together.
There you go.
Subsection 7B of the NYVRA allows towns to invoke a 90-day safe harbor where they can consider adopting a remedy for a potential violation of the NYRA. Subsection D of that provision says that if the towns want another 90 days, they must commit to adopting a remedy.
So let me stop you for a second, okay?
Yes.
So let me ask you this. The first of the 3 requirements for triggering the 90-day safe harbor is an affirmation from the town of its intention to enact and implement a remedy for a potential violation. Is that correct?
That's right, Your Honor.
And how's the town resolution passed on March 15th satisfy that requirement?
Well, it affirmed our intention to enact and implement a remedy of a potential violation of the NYRA. And the key word that we're focusing on here is potential. As we pointed out in our brief.
So I understand. So if let's imagine, for example, just hypothetically, that after conducting its own investigation, the town concludes that its at-large election procedure doesn't violate
Yes.
New York Voting Rights Act. Under those circumstances, what, if anything, does the March 15th resolution commit the town to doing?
Nothing further, Your Honor.
Right.
And yes,
So imagine a scenario where the town board concludes on its own investigation that there's no violation of the New York Voters' Rights Act, and so it takes no further action, right?
that's right, Your Honor.
Would the plaintiffs be required to wait a full 90 days before bringing a lawsuit,
Yeah, I mean,
even if the town has already decided on day 31 that it's not going to implement any remedy?
yeah, I suppose they would need to wait the 90 days at that point. Having said that, it would not be any kind of skin off anyone's nose to wait a couple of extra days. I mean, the NYVRA specifically provides in subsection F that if there's some sort of exigency, the election's coming up right away within 120 days, then they can, yes.
So let me just ask you a pointed question. You're contending that the town needs time to investigate
That's right.
whether there's a potential violation of the Voting Rights Act. Is that correct?
That's right, Your Honor.
And does the language of the statute provide that an investigation is sufficient to trigger the safe harbor?
No, Your Honor, what triggers the safe harbor is the enactment of the
Please answer
resolution.
the question that I asked, and is there anything in the statutory language that refers to an investigation?
There is not. There's also nothing in there that says that you cannot, you have 90 days. You can use that 90 days entirely
No, I'm
to,
talking about the initial period and then ultimately, because the statute is pretty specific, because the statutory language says that the resolution has to meet certain elements, and that's what I'm asking you. Is there anything in any of those elements that would suggest that you are entitled to an investigation?
what,
Is there any language that speaks about an
it
investigation?
doesn't speak about it in either way.
Okay, so you're making that inference.
No, Your Honor, I'm focusing on the word potential. The word
Right, and
potential
what
is-
about the word potential gives you support for the fact that during that second period of time, then you're entitled to investigation? I'm trying to figure out what the source of that
If I may, the word potential, we submit, and this is Black's Law Dictionary, it means possible if a necessary condition exists. So within that, we have the right to determine whether the necessary condition does in fact exist.
So what were you supposed to be doing during the first 50 days?
The first 50 days doesn't give us any obligations except for deciding whether we're going to adopt an NYVRA resolution. There's not a
And
single...
what's the point of the resolution if you still have more time to determine whether or not you're going to remedy the potential violation?
Sometimes, Your Honor, the NYVRA letter will be so obviously wrong on its face that you take the first 50 days, you don't enact an NYVRA resolution.
So why didn't the statutory language, if we go with your theory, why didn't it just say you have 140 days to investigate?
Your Honor, I do not dispute that the statute could be clearer, but what the Supreme Court said, and what my friends are saying, is that that 90-day period requires a commitment to enact a remedy. That language is in the statute, but it's only for the second 90 days. What they're doing is they're saying that the obligation that is clearly spelled out to get the extra 90 days, the 180 days, also applies to the first 90 days.
The purpose of this statutory language, because, well, just the Voting Rights Act in total, the purpose is to do these things rapidly, not, take a long time, right?
I mean, rapidly, but I mean, there's a 50, 90, 90 built in, so obviously it's not saying as fast as possible. It's like many statutes.
So there's a
trying to
50,
achieve
90, 90, but the second 90 is contingent on certain things, and so is the first 90.
Yes, and the fundamental problem with the Supreme Court's decision is that the Supreme Court conflated the contingency that's necessary for the second 90 days, what would be necessary for the first 90 days. The second 90 days does make you make a firm commitment.
Let me ask you this. Does the town need to definitively determine whether a violation of the Voting Rights Act has occurred in order to commit to a remedy?
Yeah, in order to adopt a remedy under the NYVRA, the town has to determine that there is a violation. And similarly,
So could they determine that without a violation, they could come up with a remedy?
not under the NYVRA. They may have powers under the town law to do it. And I think it's clearly seen in the provisions that talk about what happens when the town submits to the
So
Attorney
when you look at
General.
the resolution, the languages, the wherefore language that comes before it, it really talks a lot about, fairness and having everybody having an opportunity to vote. So for example, could the town decide to replace at-large elections with district-based elections without engaging in a detailed statistical analysis whether an election patterns suggest racial polarization or vote dilution?
I want to be very clear about this. The town has authority under the town law. Before the NYVRA is ever enacted to do certain things, they have a town code that can accomplish certain things. They also are given additional responsibilities, and while this has not been adjudicated, potentially additional pathways under this new statute, the NYVRA, to do things that they may not have been allowed to do before. If they are going to go under the NYVRA...
Question, who is ultimately responsible for deciding whether a violation of the New York Voting Rights Act has occurred?
I guess ultimately the New York Court of Appeals, if the case gets that high, but
So in the amicus brief by the Attorney General, they contend that the statute's use of the phrase potential violation simply signifies that the court has not yet formally adjudicated whether there was a violation. They contend that that reference to a potential violation is not intended to authorize a town to pass a merely conditional or equivocal resolution.
I do not believe the word potential is amenable to that reading. If a court ultimately determines that someone violates the law, that's
Well,
when...
until they violate the law, you shouldn't have used that example. If they're alleged to have committed an offense.
Right, but if the court determines that they violated the law, the violation of law occurred when the violation of law occurred.
You know, in fact,
it was not a potential
let me
violation.
stop you for a minute because I don't want to talk over you.
Sorry.
So anytime the court refers to someone who has not been convicted of offense, they always say alleged because they haven't been convicted. So if you want to make the comparable example, then potential would serve the same purpose as alleged.
But the statute doesn't use alleged, it uses potential. And when a person commits a crime or a municipality violates the law, that violation is complete upon the satisfaction of the elements of whatever crime or statute involved. That's not potential.
Let's talk about the governor's memorandum that was issued at the time that she signed the bill. Didn't, in fact, the reason that when the VRA passed, it really didn't go into effect until 1 year later, and couldn't the town have begun its investigation into election procedures at that time?
I mean, I suppose a town could have. I mean, in larger political subdivisions in New York who have large staffs of lawyers and maybe voting rights experts on retainer could go ahead and do that. Nothing in YVRA requires small towns of 30,000 people like Newburgh to.
No, Counsel, we understand that, but there's a reason. But you'd agree, though, with my colleague's suggestion that there was a reason why the governor gave municipalities a year, though, right?
I mean, I suppose, but right, but
I mean, you could have done it immediately, right? I mean, it's natural to assume the governor was giving municipalities, no matter how tiny they are, the opportunity to digest what was in front of them and perhaps conduct an all, whether you did it or not is irrelevant, but I mean, I just try to have a conversation in good faith, though. I mean, it doesn't seem unreasonable to me, or I wouldn't think to most people, that the governor's intention in granting that 1 year was to do just that.
I mean, I would be quite surprised if most of the towns in the state of New York conducted those sort of analysis in that 1 year. I mean,
That's not my question. Look, I'd be surprised a lot of things that municipalities do. I'm talking about the intent of the legislature, I'm sorry, of the people who put the law in place, which would include the governor. But that's all.
I don't think the statute could have, if the statute was expecting that, that's what the statute would have said. They would have said all the towns of New York who use at-large systems, which is almost every town in New York, go ahead and make this careful study. What the statute did is something very different. I think the fairest reading is it's expecting the investigation to be triggered by the NYVRA letters. Otherwise, every single
That's right,
town.
and that's why you have that initial 50 days to
Nothing.
your investigation. Or, right, isn't that what it suggests?
Nothing in the 50-day provision puts any obligation on the town besides deciding whether to enact an NYVRA
Well, they have to
resolution.
determine whether or not they're going to really risk a suit and the expenses that go with it. That's the purpose of that 50-day period, to make a decision. You can do whatever you want, but the purpose is to allow the town an opportunity to determine whether or not they're going to voluntarily remedy a potential violation. Why is that incorrect?
Your Honor, I don't disagree with the words that you just said there, and the key word is their potential. So as I see the statute, this is how it operates. For the first 50 days, you get the letter. Your only obligation is to decide whether to enact an NYVRA resolution.
So let me stop you there, because you actually made that argument already. So the second criteria for triggering the safe harbor provision is that the town should affirm specific steps it will undertake, and I'm quoting the language from the statute, to facilitate approval and implementation of such a remedy. What are the specific steps the resolution sets forth for implementing a remedy? Again, I see there's steps, but the steps really deal with conducting an investigation and reporting their findings to the board. There are also steps that set forth the town to solicit public comment at hearings. Where are the steps for implementing a remedy?
I mean, if I could just complete my answer. Those steps are, you just keep reading. You get 30 days, get the study, public hearings, and then at the end of that, within the 90-day window, you got to submit to the AG Civil Rights Division. That's the complete process, all finished within 90 days. Now, my friends argue that 90 days may not be sufficient to finish that whole process. That's exactly why the statute provides for an additional 90 days if you firmly commit to adopting the remedy. What the Supreme Court and my friends are doing are conflating these two 90-day periods. I agree with Your Honor that the first 50 days, it's a precatory period. The second 90 days is a period where that you can fairly do study, but you also have specific steps. That last 90 days, you can only get it if you make a firm commitment. What they're saying is you only get the middle 90 days if you make a firm commitment. And that conflates the two 90-day periods.
So can you walk me through, step by step, the schedule that's set forth in the March 15 resolution and why you think it satisfies the safe harbor requirements? We've already discussed that the town attorney and the town supervisor have 30 days to investigate concerns raised in the plaintiff's letter and report the findings to the town board. Do you consider that investigation and report to be part of the schedule for enacting and implementing a remedy?
Part of it, but not all of it.
Would you agree that a resolution gives the town an unspecified amount of time for considering the findings and evaluation of the town attorney and the town supervisor?
I do not agree with that, Your Honor, because there's an outer period. You have to count backwards. There's an outer period of 90 days where you got to send it to the AG.
And would you also, because you need to articulate it for me, that the board is also given an unspecified amount of time to reach its own conclusion as to whether or not there may be a violation?
You got to issue a proposed remedy within 10 days of the.
But we're looking
30-day
for
period.
a plan of implementation, so I'm asking you if that appears here, and I guess the answer is there's nothing specific. There's no,
says 10
there's
days,
no
Your Honor.
timeline, really.
With respect to, I apologize for talking over you. I do want to correct the record. It says 10 days to propose a potential remedy, and then it says 2 public hearings within 30 days. Then the whole process has to complete within 90. And that whole process, and I don't think my friends have a quarrel with the end of that process. If we determine that
No, because they say you're at the end, the one thing you do say is you can do it within 90 days.
well, you have to. Otherwise you violate your resolution. Now, of course, maybe my friends could be right that we run out of time, and then we have to come to them and say, we are willing to firmly commit to a remedy, give us an extra 9 days. If they agree to that, then we have a firm commitment, an enforceable commitment. If they say no, then they can sue, and then we'll take the 90 days at the beginning of the lawsuit. But we only get that extra 90 days, that second 90 days, if we make that firm commitment.
So if there is a violation, what is the remedy that you've proposed?
Well, the board had this, it's not on the record, but you've asked me.
Answer the question.
Yes.
What's in there that articulates the remedy that is proposed?
The remedy is not proposed in the resolution. It says that the law firm and the expert will study it.
So
As a
it
matter of-
actually doesn't have a remedy in that resolution. All there is a conditional promise that if there is a violation, you'll figure out the remedy within the 90-day period.
Not just figure it out, but submit the final remedy to the Attorney General Civil Rights Division. I mean, that's
So
the
I'll go
process.
back to my initial question, which was essentially, there were certain elements that were supposed to be included in that resolution, and one of those elements was a timetable for execution of a remedy.
That is, I don't take my friends to be arguing that that's not in there. That's the 90 days. If as I understand their argument, maybe my friend will tell me otherwise. Their problem is that we made that 90-day contingent upon the investigation concluding that there was a violation. If there wasn't that contingency, I don't think that they're arguing that submitting to the Attorney General that final request to get rid of the at-large system and say replace it with a ward system within 90 days would be insufficient. So I don't take them to be complaining about the end point. It's that they think that the commitment needed to be firm to get to that end point. And my respect,
What they've said is the resolution doesn't comply with the prerequisites that are required to get a safe harbor 90 days. That's what their argument is.
yes, but their argument is that, I believe, because they're saying that we have not made a firm commitment that we will, in fact, ultimately submit a particular remedy to the AG, not that submitting it at the 90-day mark would be insufficient.
Well, they'll have an opportunity to talk to themselves.
Yes.
Is there anything else that you'd like to add? The bench was particularly hot, so I don't know if I want to give you an opportunity to get to any points that that are in your brief that you didn't have a chance to discuss through questioning.
I think I've taken up enough of the court's time.
I want to thank you for your time. Thank you so much. Counsel.
Good morning, Your Honors. May it please the court, my name is Robert Spolzino, and I represent the plaintiffs in this case. I want to talk about the text.
Let me stop you for a minute. You know I'm not.
I didn't think Justice Chambers would let me get too far.
No, I'm not going to let you talk. So what is your response to the defendant's contention that 50 days is not a reasonable amount of time to investigate a potential violation and determine an appropriate remedy, and therefore this is not what the legislature could have intended? That's their argument.
My response is that the legislature decides what's a reasonable amount of time, and that if you look at both the language, which I'll get back to, and the practical aspect of this, it has to be enough time. And I want to go back to what I was going to say was I want to talk about something my friend Mr. Zeitlin brought up, which is whose nose the skin is off here, right? The skin is off the nose of the voters here, not the town. These are voters whom we allege have been disenfranchised within the meaning of the New York Voting Rights Act. Now, that hasn't been proven yet. We believe it will be proven when we start this trial on October 31st.
Right.
But the voters are the ones who aren't allowed to vote. We raised that contention with the town in January of last year. And we raised it in January of last year for a reason, recognizing that there was this 50-day time period, and also recognizing that there is an election coming up for local office in 2025. And the entire goal was to get to a resolution in time for that election.
So I think they would suggest that given that there's no exigent circumstances here, that why isn't it appropriate to interpret the statute as allowing the town time to investigate the allegations and develop a remedy rather than compelling them to immediately commit to a remedy when a violation may not exist?
It would have been great if they had committed to a remedy. We would have been very happy with that. But, and there is a circumstance, there's a provision of the statute for a very brief exigency. But the facts of this case establish that would have been very difficult to achieve. I mean, we started this case in January. We made the notice in January. We started this case in March. We finished discovery a couple of weeks ago. In fact, last week we had the last deposition. And Justice Vasquez-Doles is pushing this.
I'm going to insist that you answer the question that I asked you. So if you don't want to answer that question, I'll ask you.
No, I'll be happy to answer it.
Okay.
Your Honor. You started with whether there was a reasonable basis for the 50 days.
Right.
And I'm trying to explain that that this case demonstrates that there is. But regardless of whether it's reasonable or unreasonable, it's what the legislature said. And if you go
To that point, the defendants contend here that there's nothing in the text of the statute obligating them to a specific remedy within 50 days. So what's your response to that?
they're obligated to commit to remedy and to a remedy. The critical word here is not potential, although I'll talk about that. The critical word is if. There's no if in the statute. There's an if in the resolution. If we determine that there's a violation, then we'll do something.
But on a very practical basis, how can a town commit to a specific remedy without first conducting an investigation?
They can, and that's what they have 50 days to do. They can. These studies are not magic. They're not. They don't require depositions. They're an analysis of numbers to get to the racial polarization issue. There's no reason they can't do that. There's nothing in the record that establishes that even that the town tried and got to the 49th day and couldn't, so they passed this resolution.
But I guess the point is, the defendants are also noting that there's nothing in the statutory language obligating them to perform an investigation in the initial 50 days after receiving the what's it called, a pretrial letter, pre-suit letter, right?
That's right, because
So given the statute's silence on imposing any requirement upon a political subdivision in the first 50 days, apart from passing a resolution. What is the rationale for demanding that the defendants complete their investigation into the plaintiff's allegation within that specific time
The
frame?
statute doesn't demand that they complete their investigation within those 50 days. It commands that they make a decision if they want to take advantage of the safe harbor. And so they can commit to fix the problem. These are all folks who live in the town. They know what the issue is. They could very easily commit to fix what they recognize as a problem. Statute doesn't compel them to do so. It simply says we can't sue for that period while they're given an opportunity to think about it. What the statute doesn't do is give them 50 days to think about it, and then another day, 90 days, to think about it. All the while, the case is being delayed so that voters can't assert their rights under the New York Voting Rights Act.
Right, so the defendants contend that you're reading the word potential out of
Right.
the statute. So what's your response to that?
My response is, I would focus back on the absence of the word if in the statute. But when we get to potential, right, what does potential modify? Right? It modifies potential violation. The statute doesn't say you have to enact a resolution saying we'll potentially modify remedy a violation. It says we're going to remedy a potential violation. Because at that point, as I think Your Honor pointed out, it hasn't been adjudicated. That's all it is a potential. We're claiming there's a violation,
My questions are just questions.
but there is no violation until that point. So all they could remedy is a potential violation. And what I would suggest is what the legislature was trying to do, what the language suggests to me, is that the legislature was trying not to put the municipality in the position of admitting wrongdoing. The legislature wants to fix the problem, not worry about admitting wrongdoing here.
Mr. Sposino,
This is
just-
about fixing, I'm sorry.
No, pardon me for interjecting. Just, there was no legislative hearing here, was there?
I don't believe there was.
Probably would have been helpful had the legislature perhaps brought it. Well, I'm just mentioning it because this is an opportunity. I don't think they're going to listen to what I have to say, but this is an opportunity, would have been an opportunity to really hear from municipalities across the state, and maybe an issue such as this could have been fleshed out had there actually been live witnesses. I know it's an antiquated thought process to actually do a hearing on something like this, but it would seem to me that a legislative hearing probably would have solved some of the problems that at least what we're trying to interpret right now.
It may have, Judge, but I suspect, although I can't testify to this, that there was a normal give and take in the legislative process where interest groups like NICOM, the Association of Towns.
I'm sure it all happened behind closed doors. I'm sure it all happened behind, oh, Lord knows it happened behind closed doors, Mr. Sposino.
Right.
It was for the world to see, more importantly, for perhaps the four of us to have seen.
Doesn't help you.
That doesn't help me what happens behind closed doors, no.
Right, but I think the text is clear. I would rely on the text.
So let's get back to the text just for a second. They're claiming they're not conflating the purpose of the initial 50-day period with the purpose of the 90-day safe harbor period. They contend that the 50-day waiting period provides a political subdivision time to decide whether to enact a resolution at all, whereas the 90-day safe harbor provides this political subdivision with time to investigate whether there may be a violation and enact any necessary remedy. Why isn't that a fair interpretation of the statute?
Respectfully, I think that's completely inconsistent with the plan that the statute lays out. The statute says you have 50 days to think about it and decide whether you're going to make a commitment. Taking an action requires time. The second piece is to protect the municipality that has decided it's going to remedy the problem from being sued while it's doing that. And we completely understand. We would have been perfectly happy if the town had committed to do that and said, here's what we're going to do. We're going to draw a map. We're going to hold a public hearing. We're going to put forward a local law.
The only thing that you're concerned about is that it was conditional. It wasn't that there wasn't a remedy and a way to implement it. That's his argument.
Well, I'm not sure I understand that argument, Your Honor. There's always a way to remedy it. They could remedy it today if they wanted to.
Well, they didn't, what he's saying, you don't take exception to the fact that the remedy is not part of the resolution.
Oh, I think they had to decide on some remedy, but if they had said, and this is not the case here, so I'm speaking hypothetically, but if they had said, we're either going to do districts or we're going to do ranked choice voting, and we're going to accomplish either one of those in the next 90 days, I don't think we would be here. I think we would have waited the 90 days while they did it. But they didn't say anything, that they were going to do anything. They said, if we think there's a problem, after 50 days, if we think there's a problem, then we'll think about what we're going to do. And that, I would suggest, is clearly not the intent of the legislature. It was not the intent of the legislature to give them 140 days to figure this out. It was not the intent of the legislature to let people wait, let voters wait for 140 days until it was too late to fix the problem, because not considering the statute that's being litigated about switching to even years, that would have meant that the remedy, the case begun in 2024, the notice given in 2024, would not have become effective until 2027, even if we won. That can't have been the intent of the legislature. And we didn't bring this immediately after, but we brought it within 6 months of the statute becoming effective. So there was no intent on our part to delay. We wanted to move this case, and we've pushed this case as quickly as we can.
Again, the bench is particularly hot with you as well. Is there anything you want to add that you haven't had an opportunity to address during your argument?
No, thank you, Your Honor. I think I'm fine.
Okay, it's a pleasure seeing you both. Okay, have a
Thank you.
wonderful day. Thank you for your patience with the bench. I know we had a lot of questions for you. Appreciate your time.